Way back on season 1, episode 13, we reported on the fact that Texas Attorney General Ken Paxton was suing Pfizer for misrepresenting how effective their COVID-19 shots were. This was particularly interesting to us because the trial was scheduled for district court right here in the LBK. Now, just to recap a bit before we get into the updates about this lawsuit, I wanted to kind of remind y'all what we talked about way back then. We basically read the trial documents out, and it says in the trial documents that were filed by the state of Texas that Pfizer and its partner BioNTech touted their vaccine as 95% effective against COVID-19 infection in company statements. But the efficacy estimate was a relative risk reduction for vaccinated individuals when compared to unvaccinated participants. Of vaccinated participants who had no prior evidence of infection, get this, 0.04% tested positive for COVID-19. Now, of the unvaccinated participants who had no prior infection, 0.9% had a COVID case. According to Pfizer and BioNTech, that meant that there was a 95% relative risk reduction. This is very important, relative risk reduction, because there's a whole nother way to look at this, and that's called absolute risk reduction. And it's the preferred method because it's more accurate. Absolute risk reduction, another way of measuring, according to these trial documents, is determined by subtracting the post-treatment risk of, get this, these numbers, man, 0.04%. You take that and you subtract it from the baseline risk of 0.9%, which when you do that, you come up with a whole different efficacy rate or estimate. Attorney General Paxton says that Pfizer misrepresented the efficacy by promoting the relative risk reduction number, 95%, and relying on just 2 months of clinical trial data, according to the lawsuit. He says, quote, of 17,000 placebo recipients, people are in the vaccine trial, they had 17,000 who were placebo recipients, meaning they did not get the vaccine. Only 162 of them acquired COVID-19 during this 2-month period. And he says, based on those numbers, vaccination status had a negligible impact on whether a trial participant contracted COVID-19. He goes on to say the risk of acquiring COVID-19 was so small in the first instance during this short window that Pfizer's vaccine only fractionally improved a person's risk of infection. And a vaccine recipient's absolute risk reduction, which is, by the way, as I said, the more accurate measure, and it's the Food and Drug Administration's preferred way to measure efficacy. When you use that measure, it shows that the vaccine was only 0.85% effective. Not 85% effective, 0.85% effective. Basically, when you subtract the people that got infected by the people that didn't receive the vax getting infected and the people that did get the vax getting infected, you subtract them, you get 0.85%. Another way of stating that is what they call the number needed to treat or the number needed to vaccinate. In this case, you needed to vaccinate something like 119 people to prevent one case of COVID. One case of COVID, not a death, one case. 119 people to prevent one case. So anyway, going on with the documents from the lawsuit, the FDA has stated in guidance documents that relative risk estimates made that the reduction rates seem large and that treatments are viewed more favorably than when the same information is presented using an absolute risk format. So in other words, not quoting the documents, just explaining, they like to use relative risk reduction because it makes the number high, 95%. But if you do the real honest math on it, the absolute risk reduction is 0.85%, which is the preferred method that they should use to tell the patient, hey, this vaccine or this medicine or whatever, it only has a 0.85% efficacy rate, meaning it reduces your risk by 0.85%. That's not even 1%. That's why they don't use that, because you realize that they're ineffective, right? You wouldn't take something, hey, you have a low risk of getting this disease anyway, but here's a dangerous medication, a potentially dangerous medication, and all medication is potentially dangerous. Here's a potentially dangerous medical intervention that will reduce your risk of getting something by 0.85%. You would go, what? 0.85%. That's not even 1%. So, just explaining there, I wanted to take a moment to provide an update on the trial because that was last year, basically last December. So here it is about a year later. The update comes out, and I'm going to give you the bluff, or the bottom line up front, as we used to say in the Air Force. The bluff, the bottom line up front, is that the suit was dismissed. But wait, it's extremely important to mention why it was dismissed. Now, before I get into that, let me tell you why it wasn't dismissed. It wasn't dismissed because the facts of the case were wrong. It was not dismissed because Attorney General Paxton didn't prove his case. It was not dismissed for any lack of evidence or any other good reason at all. Get this. It was dismissed because vaccine makers are pretty much immune to being sued. Unlike any other product on the market, you basically cannot sue a vaccine maker no matter how much they lie about their product or how many people their products injure, maim, or kill. All vaccines that I'm aware of, I've studied the matter a little bit. I ain't nobody special, but I like to read, and this is one of my subjects I like to be informed about. And all the vaccines that I'm aware of are protected by what's called the National Childhood Vaccine Injury Act, the NCVIA of 1986. If you want to know, that's federal, that's 42 U.S. Code. I think it's paragraph 300 AA 1 to 300 AA 34. Like you care. But if you want to look it up, it's the National Childhood Vaccine Injury Act. This act was signed into law by President Reagan back in 86 as part of a larger health bill on November 14th, 1986. The NCVIA's purpose, get this, the sole purpose of this act was to eliminate the potential financial liability of vaccine manufacturers due to vaccine injury claims. Now, the context is important here. 1986 is when Reagan signed this act. In 1986, that's really the height of the Cold War. The Cold War ended in about 1989 with the collapse of the Soviet Union. But during the Cold War, we were basically at war with Russia in all but shooting guns, in every way except shooting guns. That's why it's called the Cold War. So as I understand it, the vaccine makers back in 1986 were being successfully sued to the point that it was hard to stay in business. Their products were hurting people and they were getting sued and they were about to go out of business. So essentially, they issued a veiled threat to Congress and the president and said, you're like, hey, yo, if you don't give us immunity to these lawsuits, we're going to go out of business. And if we go out of business and then the evil Soviet Union comes and uses some kind of germ warfare against us, then you going to be up the creek because we won't be here to develop a vaccine quickly. In fact, in the legal briefings at the time, Congress called certain vaccines, the ones listed in the act, as unavoidably unsafe. That's why they were getting sued out the wazoo, because the product was unavoidably unsafe, meaning the way they knew how to make them at the time, and even today, they couldn't do any better than making them unavoidably unsafe. So in this particular lawsuit that we're talking about, the judge cited the PrEP Act as another reason that he dismissed the lawsuit. So the official court documents state, and I quote, after careful consideration of the arguments, applicable law, and circumstances presented, the court finds that the motion to dismiss is granted. More specifically, the court finds that as a matter of law, under the circumstances of this case, the defendant, that means the vaccine makers, are entitled to immunity under the Public Readiness and Emergency Act, the PrEP Act. So he says it right there. We dismissed the case because, according to the PrEP Act and the National Childhood Vaccine Injury Act, you can't sue vaccine makers. According to the PrEP Act website, they tell you right there, it says a PrEP Act declaration is specifically for the purpose of providing immunity from liability and is different from and not dependent on other emergency declarations. So basically, the judge in this case punted by pointing out that you can't sue vaccine makers by law. As far as I can tell, he did not mention that any of the facts of the lawsuit were wrong. Didn't say anything about the evidence or the proof. He just said, I dismissed this because the PrEP Act and the National Childhood Vaccine Injury Act of '86 says you can't sue vaccine makers. So case dismissed. Bye-bye. Basically, no matter how you slice it, it's nearly impossible to sue the vaccine makers if you are vaccine injured. I say nearly because there is an attorney called Aaron Siri who's down with the Informed Consent Action Network. He's also, as I understand it, he is Robert F. Kennedy Jr.'s personal attorney. Well, Aaron Siri, this guy, has found ways to successfully prove vaccine injury and fraud in court. So there's at least one law firm out there that knows how to beat these guys. But with all that in mind, did you know that it was nearly impossible to sue vaccine manufacturers even if their product causes provable damage or injury? Let me ask you this. Can you think of any other product that gets a free pass from lawsuits like this? Another question, would you use, if you knew in advance, would you use any other medical product if you knew that you basically had no remedy in the court if the product caused you harm? I know I wouldn't. Oh, yeah. And before we go, another interesting tidbit. Did you know that the Biden administration, on the way out the door, just extended the COVID-19 emergency until 2029? Let me ask you this. Do you feel like we are in an emergency? Wonder why they would extend it then. Bet it has something to do with money and immunity. All right. I'm out the door, y'all. I'm gonna leave that on your heart right there and on your mind. Let me know how y'all feel about that. Did y'all know this stuff? Were you just now informed about it? If so, how do you feel about it? Let us know. All right, LBK. Until next time, we're going to try to get some future guests in studio to talk about this kind of stuff, this kind of medical issues, these kind of medical issues, and other important things. Y'all stay tuned. Thank y'all for the support, and peace.